Hey guys, we're here for class 11 of Fundamentals of Research, Legal Research. We're really going to be working on the elements of your memorandum and the differences between predictive and persuasive writing. So I think we talked about it in our last lecture, but a predictive writing is one that the object is to say what the probable legal outcome says, what the law is going to be. It's not about arguing your case. You're not Perry Mason in front of the judge. You're just someone who's trying to figure out what the answer is. Okay. And when we're writing a predictive writing, it's usually an internal type audience. We're writing it to, if we're a paralegal or a young associate, we're writing it to the partner in charge of the case, or even to ourselves. A persuasive type writing might be something you might be more familiar with. It might be like a motion or an appellate brief. So it's designed to persuade whoever's reading the document that what you're arguing or what you're stating in the document is true, that the outcome you are advocating for is more desirable. So you can kind of see the different styles of writing just from that. And for a persuasive writing, you're usually just writing to the court, to the judge. Okay, so when do you use a predictive writing? When you want an objective evaluation, when you just want an answer to the question. You're going to say, well, courts usually rule this way or they usually rule that way. It also might come up with more questions, either factual research or different. It might come up with more questions as you're writing it. And the legal researcher's job is going to be perform research that will be used either to inform a client or assist the attorneys in how they're going to proceed for the case. Okay, it's not argumentative, it's not persuasive, and you have to figure out what the questions are that need to be researched. Okay, so you might want to talk about this a little bit. And I think I talked about this in our last lecture, but you have to think of yourself in a predictive type writing as what we call a devil's advocate. Okay, you have to look for how the other party might be arguing, the other side. Okay, if you might have a friend or who will always take somebody else's side in an argument, even if they don't believe it. Okay, so that's the role of the devil's advocate. So if you're writing this predictive type writing, you're going to be looking not only to the best strategies for your client, you're going to be kind of wanting to figure out what strategies the opposing party might use. Okay, so that's the role of the devil's advocate. So you have to find the law and arguments on both sides so you don't miss anything. Okay, an advocacy type memorandum is persuasive writing. Okay, your audience is someone outside of your firm or your client, zone of comfort. Usually it's the judge, and you're trying to convince whoever the reader is to take certain action, rule in your favor, dismiss the case, proceed, rule in your favor in some way. So there's a points and authority memo, which would be a memo in support of a motion, a trial brief, appellate brief. All of those are examples, or a motion itself too, are examples of advocacy type writings. Okay, so we talk about advocacy. Advocacy means you are trying to act on behalf of your client in a positive way towards them. Okay, so an attorney, part of what their duties are when you swear your oath is you have a duty to be a zealous advocate for your client. So you might say, oh, how do lawyers defend murderers and something like that? It's part of their ethical duty. If they have taken on this client, they have a duty to be the best possible representation for that client. Just like a doctor takes an oath to do no harm and to help people, even if they're, they might not, they can save murderers as well from death, things like that. So you have to represent your client to the best of your ability. And you have to present the law favorable to the client, to the court, and the opposing party. So you only want to find, you're going to do your best to find a law in favor of your client and to the detriment of the opposing parties. Okay, so our types of legal writing, we have our memorandum of law. So just your straight memorandum of law is objective, a predictive type writing. You're given a specific fact pattern, a situation. This is just like our final research paper. Okay, and your job is to research and find the strengths and weaknesses of the probable positions of both parties and predict the probable outcome. And at the end, you recommend the most favorable strategy for your client. So that's the memorandum of law if it's internal. Now, at a memorandum of law, if it's external, it's usually a memorandum of law in support of a motion. That one, you would be emphasizing the strengths of an advocated position, you minimizing the weaknesses of your argument, and arguing for a favorable decision on the part of your client. Okay, other things you have is an opinion letter. So an opinion letter written by an attorney, and it's a client has requested a formal opinion, and the attorney will give, it's again a predictive type writing, and it will be the correspondence by the attorney giving their legal opinion on the strengths and weaknesses of their cases and their side and the best possible option for proceeding. Memorandum of points of authorities, again, that's like a memo in support of a motion that advocates your client's position. Trial brief. So a trial brief, before you proceed to trial, a lot of judges require that you file what's called a trial brief. So the trial brief will have all your allegations, the plaintiff's allegations, and all the defendant's claims, answers to those allegations. It will have all of the witnesses that you expect to call at trial, all of the evidence and documents you intend to produce at trial, and also memos about any anticipated legal arguments that are going to be raised at trial. So it's a big, long document, very, very time-consuming. But a lot of times these trial briefs are filed, and then the judges look at both sides and then maybe forces both clients to come down and have some sort of mediation with the judge before the trial actually starts. Trial briefs are usually for civil litigation. I don't think they require those for a criminal case. Criminal cases move much quicker than that. Okay, an appellate brief that is filed when you are appealing a decision. So either in support of your appeal or against someone else's appeal, and it deals with legal issues, claimed errors of a legal nature made in the lower court. Okay, so back to memorandum of law. If you go to law school and you start working at a big firm, you might be assigned memos. You'll be assigned memos in other courses here at Harper. The audience is your supervisor. It's an internal document, and again, it's a predictive form of writing. Okay, this is our Advocacy Memorandum. This just is a note that if you're filing anything with the court, every court has their own particular rules. Okay, so there might be things like, what's the format? What should the caption look like? How many copies should be distributed? Or should it be filed electronically? What citation format they prefer. So before you file any document with the court, this might be something that is your job, and maybe talk to the legal secretary as well but you might have to make sure that any document filed with the court has to comply with their court rules. Things you're going to see in any document that is filed with the court, you're going to have your case caption once it's filed, right? The parties, the docket number, the court, and then the title of the document. What is it? Is it a motion? Is it a brief in support of a motion? Is it an order? Whatever it is. And then if you are requesting something, your prayer for relief. If you're dealing with a complex legal document, with the court, you're going to have a lot of extra stuff. Okay, so complex or long things like an appellate brief, you're going to have things like a table of contents, a table of authorities, your statement of facts. If it's with a court, if you're filing a statement of facts with the court, you're going to have to support those facts by something, either the record, testimony, a deposition, or an evidentiary document, or a declaration, an affidavit, something like that. You're always going to have your issues. Sometimes they're called questions presented. In something with the court, you call it an argument. If you're in a predictive type legal document, you're calling it a discussion or an analysis, and then your conclusion, and then your signature. You're also, if it's a complex legal document, you might have a prayer for relief as well. So what are you asking the court to do? Okay, when you're writing persuasive, you want like clear, concise, direct writing, just like we talked about last week, right? Short sentences, the KISS, keep it simple, stupid, avoid run-on sentences, avoid the passive voice. Important points, repeat them, say them over and over again. There's like all sorts of studies that like if you say something once, people don't believe it, but the more you start saying it, you say it over and over again, then people find it more and more credible. No, I heard this here, I heard this there. Our politicians use these tactics a lot. When you have your point headings, remember our headings in front, you can make them persuasive. The court erred when deciding blah, blah, blah. You can, even your headings, you can make them in a persuasive fashion. And like after you write a rough draft, just kind of more of a predictive way, and then you tweak it and you use your editing as an opportunity to make it more persuasive. Okay, our Memorandum of Points and Authorities is our persuasive document filed with the court. So this is usually, a memorandum in support of a motion. That's kind of what they call it in our jurisdiction. Okay, so you file your motion with the court. After your original motion is filed, the court sets a briefing schedule and a date for oral argument. Okay, so you have the moving party files their memo in support of a motion, and then it's called the response is filed by the party opposing the motion, and then the reply would be the moving party has one last chance to answer what has been brought up by the opposing party in the response. Many times, these memorandum of points of authorities are supplemented by declarations or affidavits. So the person who is stating these facts make a written statement upon penalty of perjury. They sign it, and the affidavit is signed. The declaration or affidavit is signed and sworn before a notary. They're usually made by either parties to a lawsuit or someone saw something in a lawsuit, and they spell out all the facts that they're swearing to, which is part of your statement of facts in this motion. And you refer to those declarations or affidavits in the actual text of the Memorandum of Points and Authority. Trial brief, okay, everything, and these can be created in preparation for an arbitration as well. It has everything that is expected to occur at the trial or arbitration, right? I think I just talked about this. Witnesses, evidence, arguments, jury instructions, proposed jury instructions. I didn't say that before. It has your arguments are backed by legal research. You might have cases or statutes that back what you're claiming. And then sometimes a judge can rule on something before trial, like we want to exclude this sort of evidence or we want to include this sort of evidence. And then it makes for a more efficient trial. There's no surprise witnesses. There's no, you don't have to take the jury out of the room to argue a motion. And it's intended to address all anticipated issues that will occur at trial. And it's your first opportunity to get the judge on your side. You're trying to persuade the judge that your client is right on all issues. And again, this would obviously be a persuasive type writing. Appellate briefs filed with the appellate court in support or on opposition to an appeal, and it's obviously persuasive. Interoffice memorandum. Okay, so this is what we're going to be working on for our final project. How to determine, use to determine what you're going to do next in a case, what to expect at trial, or merits of different arguments. Do I have enough to file a motion for summary judgment? Should I try to dismiss one or two counts of this complaint? What are my available counterclaims if a complaint has been filed against me? And again, that's a predictive form of writing. So for your interoffice memorandum, you have the option of having either it be a simple or a complex format, and we're going to talk right now about a complex one in anticipation of you writing your outline for your final paper, which is going to follow this complex format in chapter 16 of the Stasky book, the navy blue book. What's the page? I think it's like 187. Yeah, it kind of starts, page 190 to like 193. Is kind of the outline section of it. Okay, so a complex memorandum of law. You'll probably be assigned different forms of memorandums of law. If you take my CALR class, you'll have some more of that. But you have other things like, if you look on page 192 of the Stasky book, I don't have this as an ebook, so you're going to have to pull that out. You can pause me while you pull it out. But figure 16.6 is your, actually, figure 16.5 on page 191 is your table of contents. So that's at the beginning of the memo. You have your heading, and then you have your table of contents. In this table, you have the major topics to be treated in the memo and where each page begins. So you have your topic headings, and it should be brief. But look at page 16, figure 16.5. Have all your topics and then the page that it appears on. Obviously, you can't complete your table of contents until after you write your paper because you don't know what page everything is going to be on. But it's kind of a start of an outline for you. The next thing that you want to include in your complex memorandum of law is a table of authorities. So a table of authorities is a listing of all authority that you cover in the memo. Okay, so if you look on page 192 in the Stasky book, figure 16.6, you have cases, then you have constitutions, then you have statutes, and then you're having secondary sources. So separate it out by cases, constitutional provisions, statutes. If you don't have any of those, you don't have to include that. Write out them in the order that they first appear, and then put the pages that they appear on. If you discuss them more than once in your memo, then they appear on multiple pages. So you follow that format in page 16.6. Okay, so then the next thing is you have your summary of issues and conclusions. So then you're writing down each issue that you're going to be discussing in your memo separately, and then a brief conclusion, issue and answer. Okay, so obviously you don't complete the answer until you figure out what the answer is, but that is just a one sentence answer to the issue question. I guess I'm missing something. So kind of going ahead of the slides. But remember, our heading is our to, memorandum on top, to the reader from the writer, the date, and then the regarding, like that. Okay, then here's our table of contents. Here's our table of authorities. Here's our summary of issues and conclusions. Then the statement of assignment. What have I been asked to do? If you look on page 193, this is kind of your general outline here, how it's going to look. You've asked me to perform research on blah, 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 for blah, blah, blah client, whatever that is. Okay, facts. Give a summary of all the relevant facts, not too long. Make sure after you write your memo, you go back and look at your facts section to make sure anything that you are using as a fact in your discussion section is also included in the statement of facts. Make sure it's well organized and obviously accurate. Okay, so you can see that on page 193. Okay, then our analysis, we're going through our issues one by one. Every issue has a separate heading. Make sure it's well organized. Break each of your rules into elements. If you cite to a case, what are the elements of the common law doctrines, and what are, if it's a statute, what are the elements of the statute? Then decide if the elements are satisfied. If you're comparing cases, make sure your facts are sufficiently similar. Make sure, and this is part of the rubric on the final paper, that you have what's called counter analysis. This is the devil's advocate. Any law that might work against your client. Okay, then a conclusion, brief answers, summary of your answers to the issue. Again, state them again, even though you might have stated them in the analysis and you may have stated them in the summary of issues and conclusions. Summarize them again, and then just your personal opinion on which side has the strongest argument and why you've reached those conclusions. Okay, then you have recommendations. So you have your legal conclusions. What should we do next? Should we file suit? Should we file a motion? Should we dump this person as a client? Do we need to perform any additional factual investigation? Do we, what do we need to do? What is our course of action? Okay, then there is an appendix. There may or may not be appendix, which if there are additional materials that you rely on in the text of your memo, like, an affidavit, a document, trial transcripts, deposition transcripts, photos, medical records, anything that you may have referred to in your memo, you don't have to include an appendix. If you want to make up stuff and add it, have at it. I think we talked about this last week. I think this slide is misplaced, but that chart on page 185 of Statsky, which I guess is in this chapter, so maybe it does belong here. It's just a little flow chart on how you're going to, once you read your facts, figure out what the rules of law are. So hopefully we'll be talking about that individually with you guys this week. But based on the facts, what are these potential rules of law? What you have to prove? So definitely go through that on page 185. All right, guys, I look forward to seeing you and meeting with you to discuss the issues. Make sure you bring a hard copy of your issues to the, I don't know why this is here, to the lab this week, and I'll see you then.